And from Elgeyo Marakwet, we come back to Nairobi and want to take you straight to the court, where a case that will be seeking to compel NASA presidential candidate Raila Odinga to take part in the 26th of October elections is currently underway, and we want to just get the latest from that end as we keep up with the developments around this case.
Touches on the task of our agencies such as political parties which deal with the early stages of nomination. It touches also on election management by the Independent Electoral and Boundaries Commission. Therefore, outside the framework of the events of the day of presidential election, there may well be a contested question falling within the terms of the statute of election or of political parties. Yet, still, the dispute would still have clear bearing on the conduct of presidential election. The court then proceeded to state, does the entire question concerning presidential election belong to the Supreme Court's jurisdiction, or is the Supreme Court's power limited to the express language of Article 140 of the Constitution? Besides a reading of Article 872 alongside Article 163.3 suggests, as we perceive it, the Supreme Court was intended to adjudicate upon all such disputes as would arise from the presidential election. We found no reason to presume that the framers of the Constitution intended that the Supreme Court should exercise original jurisdiction only in respect of a specific element, namely disputes arising after the election, while excluding those disputes which might arise during the conduct of election. It is our unanimous opinion that the validity of the presidential election is not for determination only after the administrative pronouncement of the final result. At any stage of the critical steps of the electoral process, the Supreme Court should entertain a dispute as to validity. End of quote. The above observation is plain that the Supreme Court can deal with the disputes relating to presidential election at the critical stage of the presidential electoral process. In that context, therefore, the jurisdiction of the Supreme Court is not limited to disputes arising after actual declaration of presidential election results, but is triggered once there is active presidential electoral process. In such circumstances, disputes on the presidential election, like the one before me, would belong to the Supreme Court. In the matter of Interim Independent Electoral and Boundaries Commission 2011, which dealt with the interpretation of the date on the date of the first election under the 2010 Constitution, the Supreme Court deferred the matter to the High Court, though stating that quite clearly the High Court has been entrusted with the mandate to interpret the Constitution. This empowerment by itself, however, does not confer upon the High Court an exclusive jurisdiction. The significance of the Supreme Court's statement in the gender representation case is that it has wide jurisdiction than that the impression created from a lateral reading of Articles 163.3 and 140 of the Constitution. I must admit, however, that this court has power to enforce decisions of the Supreme Court. Section 27 of the Supreme Court Act, number 7 of 2011, provides that a judgment, decree, or order of the Supreme Court may be enforced by the High Court, as if it had been given or made by the High Court. For this to happen, there must be a judgment or order capable of being enforced if this court were to call into action Section 27 of the Supreme Court Act. On the other hand, Section 28 of the Supreme Court Act provides that the Supreme Court shall have the same power and authority as the High Court to punish any person for contempt of court in any case to which subsection 1 does not apply. Subsection 1 deals with contempt committed in the face of the court. That means the Supreme Court can deal with any issue of contempt if of its contempt of its decision or orders. As it stands, at this moment, An active and critical presidential process is ongoing in the country. The prayers sought in the petition target that electoral process, and if the orders sought are granted, they will, to some great extent, determine the question of validity of that presidential election. Although Prayer A is couched as if it were for enforcement of the order of the Supreme Court, there is nothing really to enforce because IBC has done what the Supreme Court directed it to do. If there be contempt, the Supreme Court can deal with that issue. Prayer C asks this court to find that 6th and 7th respondents have committed contempt of the same court decision of 1st of September 2017. This will not be in accord with Section 28 of the Supreme Court Act, which gives the Supreme Court power to deal with contempt committed in disobedience of its orders. Further still, Prayer D asks from this court a presumptive declaration that whatever happens before or during the fresh presidential election of 26th of October 2017, notwithstanding that the election should be deemed to be valid. This prayer seeks orders that only the Supreme Court can make regarding the conduct of fresh presidential election. On the other hand, Prayer B is in a manner of speaking couched so as to find the 1st to 9th respondents to have committed unlawful acts which amount to electoral offences under the Election Offences Act, or was still treasonable acts under the Penal Code. That would amount to trying people for criminal offences other than in the manner prescribed by law. In other words, the petition seeks to have this court convert its process into a criminal trial and ultimately return a conviction against some of the respondents. Prayers E also urges this court to make a finding of commission of illegal and treasonable acts should the fresh presidential election not be held due to conduct of some of the respondents, and further, that the nomination of the 6th and 7th respondents be deemed to have become null and void due to their conduct and actions. Without going through each and every prayer in the petition, I think I have done enough to demonstrate that the common denominator in all the prayers is that the petitioner has sought orders that will, in one way or another, affect the fresh presidential election. Clearly, some prayers can only be granted by the Supreme Court, while others require a different trial process other than by this court. I have taken trouble to enumerate, at least in summary, the prayers as sought in the petition to just show how much the issues raised therein fall outside the mandate of this court. They follow within the jurisdiction of the Supreme Court and the other courts. They do not, in my view, fall within this court's jurisdiction of interpreting the Constitution and enforcement under Article 165(3)(d), unless, of course, this court is engaged in a creative and/or innovative interpretive maneuver. In the course of his submissions, Learned Counsel Mr. Kibe Mungai, by relying on the decision in Kipkaria Kiprono Kones vs. Republic and another shown above, contended that it would be better to have a defective election than there being no election at all. In that regard, Learned Counsel submitted that the petitioner, being mindful of Article 3(1) of the Constitution to respect, uphold, and defend the Constitution, sought the orders in the petition for that purpose. On that basis, Learned Counsel submitted in their written submission as follows. Given the fact that the High Court is the only court vested with unlimited original jurisdiction in criminal and civil matters, and considering the High Court jurisdiction under Article 165(3) of the Constitution, the petitioner is convinced that in the face of the peculiar constitutional challenges unfolding in Kenya, it is the business of this honorable court to protect the prevailing constitutional order, which in the first instance requires it to ensure that the fresh presidential election scheduled to be held on 26th of October 2017 will go will go on and the results declared notwithstanding challenges wrought by willful act of sabotage and criminality. Emphasis and end of quote. As I have pointed out, it is precisely because of the kind of submissions made and the prayer sought that bring to the fore the question of the jurisdiction of this court to determine the petition and grant the prayer sought. It must be clear that this court is not in charge of presidential election and cannot therefore say anything about the legality, validity, or otherwise of the fresh presidential election at this stage or thereafter without appearing to encroach on the jurisdiction of the Supreme Court. This court is bound by the Constitution and judicial precedents and must therefore play within its theater of operation. I perfectly understand the petitioner's concerns as captured in his petition and from submissions by his counsel. They paint a picture of uncertainty and desperation, not sure of what will happen on 26th of October 2017. However, this court can only exercise jurisdiction as conferred on it by the Constitution and the law, and only when it is properly seized of a matter can it render itself on it. That is perhaps why Mr. Wambua Kilonzo, learned counsel of IBC, in his submission, correctly cautioned that this court should be cautious on the kind of prayers to grant, pointing out as he did that the prayers in the petition were based on conjecture. He also contended that some of the prayers sought belonged to the Supreme Court. I entirely agree with the learned counsel that the issues in this petition do not belong to this court. This court has a wide jurisdiction to deal with constitutional issues, but they must be real constitutional issues falling within the jurisdiction of the court. It cannot extend its jurisdiction, though through craft of interpretation. Finally, I must point out that during the hearing of the petition, even in the absence of the first to ninth respondent, all counsel present from Mr. Kibe Mungai, Mr. Wambua Kilonzo, Ms. Kitiri, to Mr. Macharia were unanimous that no one can be forced to run in an election. With that concession, I do not know how this court, even if it were to assume jurisdiction, could have forced the sixth and seventh respondent to comply with the judgment of the Supreme Court, even though they were the successful parties before that court, by running in the fresh election. To my mind, no court can force a citizen, or a person for that matter, to exercise his or her right under fundamental freedoms. In the same breath, Article 38 of the Constitution grants citizens the right to make political choices. Under Sub-Article 3C, an adult citizen has a right to be a candidate for a public office or office within a political party, and if elected, to hold that office. That is a political choice to be made by the citizen. It is his basic right and fundamental freedom that cannot be enjoyed and exercised can only be enjoyed and exercised by the individual, and no one, not even the court, by an order of this court, can force or coerce one to exercise the right. That would in itself be a violation of that person's right to make a choice. In conclusion, therefore, having given due consideration to this matter, I am not satisfied that it meets the threshold of a constitutional petition. The issues raised therein, though couched as constitutional questions, fall outside the mandate of this court. The upshot is that the petition dated the 2nd of October 2017 falls by the wayside and is dismissed with no order as to causes. Thank you, gentlemen.
Hello, Mr. Time. Except that we wish to express one important objection.
Well, those are hearings from the Milimani Law Court, where Judge Chacha Mwita has actually thrown out the case that was seeking to compel NASA presidential candidate Raila Odinga to take part in the election, and he has cited that no institution, no individual has the powers to actually force someone to take part in an election. That is the breaking news coming out of the Milimani law courts, that Raila Odinga will not be compelled to take part in the October 26th election. That is the latest news coming out of the court, and this will have a significant bearing on whether the NASA candidate will be actually giving his remarks in this particular development. And that is that hearing that has been ongoing since morning, and they have declared that the NASA presidential flag bearer Raila Odinga will not be compelled to take part in the October 26th election. And as you know, a case had been taken to the courts that was seeking to compel Raila Odinga to take part in the October 26th election, which is just a day to go. So this is a sort of sense of relief to the NASA fraternity that has insisted that they will not be taking part in the election up until the reforms at the IEBC are conducted. And in case you're just joining us, breaking news reaching us from the Milimani Law Court is from the Milimani Law Court has ruled that Raila Odinga cannot be compelled to vie in the upcoming elections, and the judge has cited that this will be an infringement on the individual right of the candidate, and has also thrown out that case that had been filed by Pkosin, seeking to compel Raila Odinga to take part in the October 26th election. So that is the latest we know as of now, and of course this will have significant implications in regard to the 26th of October election, as so far only 7 candidates have confirmed participation. So we know that Raila Odinga has not indicated his participation in these upcoming elections.